I'm Drew Stevenson, and this is a lecture for my professional responsibility class on Rule 2.11 of the Code of Judicial Conduct. Here we're talking about judicial disqualification or judicial recusal. Now, for my students, keep in mind that at the end of our course, we talk about the Code of Judicial Conduct, which is separate from the model rules that apply to lawyers. Both are tested on the MPRE, but most of the MPRE is about the model rules. So in fact, talking about the MPRE, there's probably only going to be a handful of questions on your MPRE about the Code of Judicial Conduct. Most of the questions are about the model rules for lawyers. You may have as few as 4 or at most 6 questions about the Code of Judicial Conduct. And the Code of Judicial Conduct is really extensive. And there's almost too much to learn, or we could do a whole course in it. But there's a few provisions that seem to be tested a lot, maybe because they lend themselves to being turned into multiple choice questions. And this is one of those. So 2.11 is a pretty good return on investment for spending some time mastering it before the MPRE. It is tested regularly, and a lot of the provisions are easy to turn into multiple choice questions. Now, a point about terminology. In a lot of jurisdictions, you may have seen this in lawyer shows and movies, the term recusal is used interchangeably with the term disqualification. The ABA Code of Judicial Conduct, however, uses disqualification. So this is the term that you are most likely to see on the MPRE. In practice, depending on where you practice, everybody may say recusal. For the MPRE, you should learn disqualification. So let's talk about the rule. Section A starts with, a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. And then the rule is going to list a lot of situations that require disqualification. But note that here we're not just concerned about the judge's actual partiality or impartiality or bias. We're concerned about the appearance of bias, or that it would be reasonable to question the judge's impartiality. And in those situations, because it undermines the respect for the judiciary, if we have judges, no matter how fair the judge is, deciding cases where it looks to other people like the judge might have a stake in the case or might be biased, then as long as that's a reasonable question, the judge should be disqualified or recused. So we're going to start with the easy case. The judge has a personal bias or prejudice, right? This is the judge's worst enemy. This is the judge's ex, who they got a restraining order against, is now a party in the case that comes before the judge, or is the lawyer in the case that comes before the judge. Well, the judge has to be disqualified. Or if the judge was somehow involved in the matter personally, has personal knowledge of facts that are actually in dispute between the parties. Now, notice that that's an important caveat. If the judge happens to know of something because the judge watches the news or something like that, has heard about a certain phenomenon, then that's different. We're talking about firsthand personal knowledge of facts where the judge is basically going to kind of be contributing the judge's own knowledge to their view of the case. Next, we're going to have a series of these about the judge's spouse or partner, or a relative within the third degree of either of the judge or the judge's spouse. What's the third degree of relation? Look it up. Just take a few minutes and look it up in the code. It will list all the relatives, all the aunts and uncles and nieces and nephews and siblings and so forth that count. But in my experience, most of the questions on the MPRE are about the judge or the judge's spouse, to be honest. So let's say the judge or the judge's spouse or one of these relatives is a party to the proceeding, or is an officer, director, general partner, or managing member or trustee of the party. That requires disqualification and recusal. Next, let's say that the judge or the judge's spouse or one of these relatives is the lawyer in the case, is one of the lawyers in the case. Obviously, we can't have you be a judge in a case where your spouse is one of the lawyers in the case as well. And so that would require disqualification or recusal. Next, the judge or the judge's spouse or partner or one of the relatives of those of the judge or the judge's spouse is a person with more than a de minimis interest that could be substantially affected by the proceeding. Now, we're not talking about a direct economic interest that would apply too, but notice it's more general than that. And so this could be a privacy interest. In other words, the judge is concerned that information could come out that would be very embarrassing to the judge or the judge's spouse, or could damage their business reputation, or the share value of their stocks or something like that. And so any of those could be grounds for disqualification. Next, if the judge or the judge's spouse or partner or a relative within the third degree of either is likely to be a material witness in the proceeding. Imagine this situation. It seems ridiculous, right? You're a judge and it's your own husband or wife is being cross-examined. How are you supposed to be unbiased in ruling on objections to the cross-examination and so forth? Next, notice we're changing the parameters for this one a little bit. The judge or the judge's spouse or partner or parent or child or a family member that actually lives with the judge has an economic interest in the subject matter or is a party to the proceeding. So here, remember what we talked about before with more than a de minimis interest could include economic interest, but it could also apply to things like privacy and reputational interests. And here we're talking about just a pure direct financial interest in the subject matter or is actually a party. Next, let's say that a judge knows or learns, maybe because the parties, one of the parties submits a motion, that their firm has made that the lawyer or one of the law firms is a major donor to the judge's election campaign. And so, for example, in a lot of states, the state court judges are elected, not appointed, and so they have to have a campaign, and their campaign has to raise funds and so forth. And the concern is that one of the firms in town will be basically bankroll a judge's campaign expecting favorable rulings when they appear before that judge. Well, if you're a judge and you get a firm that either as a whole or in the aggregate, because of all the lawyers in the firm making their own personal contributions, you're afraid to rule against that firm because they basically helped you win election, then you should be disqualified from that case. Now, this is a rule about judges who give speeches where they pre-commit to ruling a certain way. So let's say a judge, while a judge or a judicial candidate has made a public statement, of course, other than in a court proceeding or a judicial decision or opinion, that appears that commits or appears to commit the judge to reach a particular result or rule in a particular way in the proceeding or controversy. So what are we not talking about? We're not talking about if you've been a judge already, that you've ruled on a few cases and have sort of taken a position on what the Constitution means, a certain clause in the Constitution, or a methodology for statutory interpretation that you use. That's fine, right? You're doing that in judicial opinions, and there's appellate courts that could reverse you in theory. But here we're talking about judges who give speeches at conferences or speeches when they're running for office and basically say, if I get any, drug dealers or carjackers in my court, I'm going to throw the book at them or rule against all of them, or a judge who promises to rule in favor of labor unions or against labor unions, and so forth. If the judge is pre-committed, the judge doesn't get to hear the case. Next, let's say before you became a judge, you were a lawyer and actually worked on this case. This was one of your cases, or it was one of your firm's cases. You should be disqualified from that. You shouldn't get to be the judge in a case that you actually worked on when you were a lawyer. And the same is true if you had worked in government before becoming a judge. So let's say you were a government lawyer or a government official, an administrator or agency director or something like that. And while you were there, you participated personally and substantially as a lawyer. Now, keep in mind, agency directors and agency officials may not be directly and personally involved in all the cases of their agency. But if you were, then you are disqualified once you become a judge from hearing that case that was going on while you were at the agency. Similarly, if while in previous government service, either as the government lawyer, like at the Department of Justice, or as a government official, you held press conferences and publicly expressed in that capacity an opinion about the merits of the particular matter in controversy. Either the Constitution clearly shows that we should win, or the other side's case is frivolous or something like that, because that's tantamount to pre-committing to ruling a certain way now that you're a judge. Okay, now we had a rule before where we talked about a judge who's it might become, or a judge's spouse or relative might be a material witness in an upcoming proceeding. But we also have situations where you're a judge now, but before you became a judge, you were a material witness in this very matter at an earlier stage in the proceedings. And when we say material witness, we don't mean you just were there to authenticate a document very quickly or something like that, but the trial partly turned on your testimony. The outcome depended on it. Well, then you shouldn't be the judge hearing that case if you were a witness at an earlier stage. And the same is true if you were a judge at an earlier stage in another court. Now, we're not saying that if a case gets remanded to you from an appellate court, you can't hear it. It's very common that appellate courts reverse and remand a decision and send it back to the same judge that heard it the first time with instructions about how to redo the trial or something like that. Here we're talking about, let's say you were a state judge or an administrative law judge, and you presided over a matter, and now you're a federal circuit court judge. And so you would be partly reviewing your own decision in the matter, or reviewing the intermediate decision that reviewed your decision. In any case, that's not right, and you should be disqualified. Okay, a judge shall keep informed about the judge's personal and fiduciary economic interests. And you can't know everything about another person, but make a reasonable effort to keep informed about the personal economic interests of the judge's spouse or domestic partner and minor children that actually live with the judge. And so what are we talking about here? There's plenty of busy professionals like lawyers and judges who entrust their finances to an investment advisor or a broker or someone like that. And they kind of pay a little bit of interest, that they approve of things periodically and so forth. And but they trust this person to handle their investments or handle their money. Well, that could be fine, but as a judge, you actually need to know what's going on with your investments and finances, so that you don't get blindsided by a disqualification motion, let's say on the eve of trial. What we really want is that judges are on top of things enough with their own personal life and their investments and so on, that if a case gets assigned to them, they could act immediately to have it assigned to another judge and disqualify themselves. So now, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, and that's true regardless of whether any of the specific provisions of this rule apply. And we said that at the outset, right? That A1 says that whenever a judge's impartiality might reasonably be questioned, including but not limited to these rules. So the rules contemplate that there could be situations that come up that really make it look like the judge is biased, and it would be improper for the judge to hear the case, even though it's something that the drafters of the rules didn't think of and didn't put in as a specific provision. Well, you can still be disqualified even if we didn't mention it specifically in the rules. Similarly, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. So in other words, if you're biased, you had a duty to disqualify yourself or recuse yourself, even if neither of the lawyers in the case or the parties asked for it. Think about it. Sometimes lawyers are a little hesitant to file a motion for the judge to be disqualified or recused from the case, because if they're not sure they're going to win on the motion, then they've offended the judge. They're worried they're going to have offended the judge who ends up hearing it, doing the trial. And so the judge is actually supposed to take the initiative, even if the lawyers haven't asked the judge for the judge to be disqualified. Now, on the other hand, disqualification can be waived in a lot of circumstances by the parties and their lawyers. So a judge subject to disqualification, except for that personal bias or prejudice, right, for your enemy or your ex or something like that, you disclose the basis of disqualification on the record and ask the parties and their lawyers to consider whether to waive disqualification. And obviously this is going to occur outside the presence of the judge and court personnel. We don't want the judge trying to manipulate the lawyers. And you may be asking, why would the lawyers ever or parties ever agree to that? Well, sometimes they don't want any more delays, right? The case has already been delayed a lot, and they know, maybe the lawyers on both sides know this judge and know the judge is going to be fair, and think that the grounds of disqualification aren't that serious or something like that. So if the parties are willing to waive it, then and without participation by the judge or court personnel, the judge can actually participate in the proceeding, right? But of course, you should note this in the record, and the agreement should be incorporated into the record of the proceeding. There's also a necessity exception. So the rule of necessity may override the rule of disqualification. And so there's certain situations where it's really going to create a problem if a judge is disqualified, and either because all judges would be disqualified from this particular type of case, let's say it's about judicial salaries, or there aren't any other judges the case can be assigned to. So, for example, a judge might be required to participate in judicial review of a judicial salary statute. I've actually seen cases like that. Or this, let's say it's a rural area, this might be the only judge available in that area, geographic area or jurisdiction, in a matter that requires immediate judicial action, like somebody's been arrested and we need a probable cause hearing or a temporary restraining order. Now, there's also a point of clarification here, and this is almost an exception. The fact that a lawyer in the proceeding is affiliated with a law firm in which a relative of the judge is affiliated does not itself disqualify the judge. In other words, so we're not saying that the lawyer in the case is a relative, but the lawyer happens to work for the same firm as one of the judge's relatives. That's a couple steps removed from the judge, and we don't think that's enough for clarification, but it could be, right? So it says, if, however, the judge's impartiality might reasonably be questioned. So if the judge on the opening day of trial says, oh, you're from such and such firm, my cousin works there, and I always rule in favor of that firm, or I trust that firm, or something like that, now we have a problem, right? So we were kind of assuming that it wouldn't affect things, but if it becomes clear that it does, then the judge could still be disqualified. Okay, next. Obviously, the judge has to make disclosures when there's grounds, because sometimes the judge knows that the judge should be disqualified, and the lawyers or parties aren't aware of it yet. And so a judge should disclose any information that on the record that the judge believes that the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there's no basis for disqualification. So let's say you're a judge and you're thinking, well, I think I can be fair. I do have an economic interest, or a relative within the third degree has more than a de minimis interest in this case, but that's not going to affect my decision in the case. Well, you still have to disclose it and let the parties decide. Okay, we're almost done here, I promise. The comments have some definitions and exceptions for what counts as a judge's economic interest. And these I have seen turn into multiple choice questions. So I want to cover them very quickly. So economic interest means an ownership of more than a de minimis legal or equitable interest. And so we mean something substantial. So if you own a one share of a stock that's not worth very much in a multi-billion-dollar company or something like that, that's not a that's a de minimis interest. Okay, it doesn't include mutual funds, right? So a mutual fund is a type of investment where a lot of people pool their funds, and then there's fund managers who actually make all the stock investment decisions. They're buying and selling shares, sometimes the same day, sometimes they sit on shares of a company for months and so forth. And the people who invest in the mutual fund don't have to think about it, right? So they just put it in the fund and they trust the fund managers. So that's indirect enough that just because, let's say if you are invested in a Fidelity fund, with your pension, you don't even know if on any given day your fund managers have bought shares in a particular company. And so you shouldn't, as a judge, be disqualified if it turns out later that unbeknownst to you, while you were doing a trial for a certain corporation, your mutual fund managers were buying or trading stocks in that company, again, because you don't have direct control when you invest in a mutual fund. And usually you don't even have the information up front. Okay, it doesn't include, and I don't think you'll see a question about this, interest in securities held by educational, religious, charitable, fraternal, or civic organizations in which the judge or judge's spouse or partner or parent or child serves as a director, officer, advisor, or other participant. So for example, let's say you're a judge and your spouse is the president of a local university or charity or something like that, and a large charitable organization or nonprofit. Well, a lot of times those have an endowment, right? So big universities have an endowment that's invested and so forth. And so now we're talking about a couple steps removed. So the judge can still hear cases related to a company, even though the judge's spouse, let's say, is the president or on the board of directors of a university whose endowment it happens to be invested in that company. That's a couple steps removed from the judge. Okay, next, it doesn't, economic interest does not include a deposit in a financial institution like your savings account or deposits of proprietary interests in credit unions. I call this the credit union exception. I don't think you'll see a question about this. You may see a question about bonds. So economic interest does not apply to government securities, right? So if you own US Treasury bonds, that doesn't mean you're disqualified from every case where it's the United States versus so-and-so versus some party. These types of government securities, like municipal bonds and U.S. Treasury bonds, are indirect and probably won't be affected by the outcome of this case. And that concludes our lecture about Rule 211 of the Code of Judicial Conduct.